This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we explain why the victims of a bankrupt insured must collect nothing from the bankrupt's insurer, because keeping clients' funds without right excluded the claims because of a professional service exclusion, and why profit, remuneration, or advantage when insured is not legally entitled, it is excluded. In USCC Services LLC et al. Versus Young American LLC and its insurer Endurance Risk Solutions Assurance Company, the Court of Appeals of Minnesota on April 5, 2022, resolved an insurance dispute. Appellants each obtained a judgment against an insured defendant in separate district court proceedings for breach of fiduciary duty based on the defendant mishandling funds that it held in trust for the appellants. Since the insured was bankrupt and without assets, the judgment creditors sought to collect from the defendant's insurer with a garnishment proceeding. They failed in the trial court and appealed to the Court of Appeals of Minnesota. USCC Services, through its affiliate US Cellular, provides cellular telephone and internet services, and Appellant Motorola Mobility LLC provides mobile products and services. The defendant in the underlying actions, Young America LLC, was a marketing services company that provided a wide variety of services to its clients, which included the appellants. Young American administered programs and services including rebates, refunds, incentives, and prepaid product programs that involved remitting payments to its clients' customers. In 2020, Young America became insolvent and ceased business operations. At the time, Young American should have had $493,757.19 in program funds from Motorola and $1,020,669.25 in program funds from USCC, but it did not. Appellants brought individual lawsuits against Young America, who did not answer the complaints. Endurance did not defend Young America against their lawsuits, and the appellants obtained judgments for USCC and Motorola in the amounts held by Young America and misapplied. The appellants initiated this action as a garnishment proceeding against Endurance to collect on the judgments based on Endurance's insurance policy with Young America. Endurance did not provide coverage for appellants' judgments because they were excluded by three separate provisions of the insurance policy: the contractual liability exclusion, the conduct and illegal profit exclusion, and the professional services exclusion. The district court determined that each of Young America's three wrongful acts fell within one or more of the exclusions, and therefore granted summary judgment to Endurance, concluding that Endurance's policy did not cover the judgments. Summary judgment is appropriate in Minnesota and just about everywhere else where there is no genuine issue as to any material fact, and the movement is entitled to judgment as a matter of law. Trying to get around that fact, the appellants claimed that the concurrent cause doctrine applied and that some of the acts of Young America were not excluded and resulted in the damages. The appellants posited that concurrent cause doctrine allowed coverage, and the doctrine provides the damages resulting from concurrent causes are covered so long as the covered cause is a direct cause of the damage, even though an excluded clause also may have contributed to the loss. The Court of Appeals concluded that the concurrent cause doctrine did not apply because there was only one cause of appellant's damages, Young America's wrongful use of the program funds and the individual wrongful acts. Young America's act of commingling program funds, making preferred payments, and canceling the Lloyd's policy that they also had that could have covered the loss were not independent causes of appellant's damages, and the concurrent cause doctrine could not apply. The court also noted that Endurance met its burden to show that the policy exclusions applied because the conduct and illegal profit exclusion provides in relevant part, quote, the insurer shall not be liable for loss on account of any claim based upon arising from or attributable to an insured having gained any profit, remuneration, or advantage to which such insured was not legally entitled, if established by a final and non-appealable judgment or adjudication adverse to such insured, close quote. Since Young America kept funds that belonged to the appellants and used it for their own gain, and gained a profit or remuneration or an advantage from the use of those funds, the exclusion applies. The professional services exclusion also provides in relevant part, quote, professional services means any service performed by an insured. The insurer shall not be liable for loss on account of any claim made against a company based upon, arising from, or attributable to the performance of or failure to perform professional services, close quote. Young America's duty to protect the funds were activities that were incidental or ancillary to the performance of Young America's core professional service of administering rebate programs, because the conduct and illegal profit exclusion and the professional services exclusion applied to appellant's claims. The insurance policy did not cover the appellant's judgments against Young American, and they recovered nothing. In my opinion, the plaintiffs were the victims of a business they trusted. They believed they could trust a company called Young America and gave it money to hold, only to find it wasted the money it held in trust. The plaintiffs sued Young America's insurer for the money, either stolen or just lost. The insurer refused because its policy had 3 exclusions that applied. The key to risk management is to be diligent when giving money to a company to hold and disperse. The due diligence failed, and the plaintiffs have judgments that can only be framed, put on a wall, and wish that they had never heard of Young America, no matter how patriotic the name of the company seemed. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe and you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,850 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publication for a very small fee. Thank you for your attention.